Good evening, everyone. I hope I'm audible to everyone and everyone can hear me. There appeared to be some technical glitch which has delayed the joining in. I hope all have joined and can Tarveen just confirm that everyone can see me. It is now properly streamed and there is no technical glitch. First of all, I thank the organizers of webinar for organizing these lectures and talks where we are virtually able to meet everyone whom we otherwise meet in the corridors of the courts. I hope all of us revert back to the routine at the earliest and unscathed. I wish all of you are safe and I further hope and pray that all of you remain safe. The topic of today's talk, I won't call it a lecture, which has been given to me by the lawyer's wit, is trial in a civil suit. Now, I'm conscious that mostly all of you are lawyers who are practicing in the original side and have a sufficient experience even otherwise. I'm also conscious of the fact that many of the honorable judges, senior counsels, and my colleagues have spoken on this subject at different forums and different times. So even if I'm repetitive in certain aspects, I think you will excuse me for that. I had in the beginning of my career benefit and privilege of having worked with and seen firsthand several trials in the courts in Tisazari and in High Court with various senior counsels. And even otherwise, I have been practicing and conducting trial for almost now 3 decades before the various courts and tribunals. In a civil suit, parties are governed by rule of pleadings, as we all know. And there cannot be any adjudication in the absence of necessary pleadings. Now, the trial is not just limited to the suits, but is almost in all the arbitrations and in also various civil proceedings which are conducted before different tribunals and forums. For civil suits, Code of Civil Procedure, as we call CPC, is our principal book. Many of us call it Bible, but I'll call a principal book, but definitely not the only book. Now, neither the civil suit is defined nor the trial is defined in the CPC. Though both the expressions are used at several places in CPC, the term suit has a generic meaning to any proceedings initiated by one party against another in any court of law. Now, section 26, subsection 1 of CPC says that the suit is instituted on the presentation of a plaint or in such manner as it is prescribed. Then section 26(2) states that in every plaint, the facts should be proved by way of affidavit, and affidavit should be in the form of Order 6 Rule 15A. Now we jump to Order 4 Rule 1. of CPC. My friends, I'll be quoting several of these provisions because nothing which I'll say in the trial of civil suit can be dehorse some of the sections or orders or the plead or other sections, because everything is based on the Code of Civil Procedure, Indian Evidence Act, and various sections. It is a very scientific placement as far as if CPC is to be looked into. Now, every section and every order, when it is placed and for the purposes it is placed, has to reach at the end of the following, so the judgment is passed, the decrees are passed, the issues are decided. So during my this talk, I'll be referring to several such sections, which though all of you would have read and referred to it several times, but there are certain small or very fine nuances which I can bring to your notice, which may help. Now, when I say Order 4 Rule 1, it says now the plaint should be instituted in a duplicate. Now, in Order 4 Rule 1, any other manner which appeared in Order 26, Section 26.1 has been deleted. Now, that means the civil suit is not in any other manner, but when the plaint is presented. Sub-rule 2 of Order 4 says that plaint should be in the format of Order 6 and Order 7. And when we go to the trial, the commencement of the trial is again not defined anywhere. The expression commencement of trial for the first time appears in Order 6 Rule 17, that the amendment should not be permitted after the once the trial commencement of trial has taken place. Now, as the CPC stands today, after several rounds of amendments, the sole intent is to reduce the time period in disposal of the suits. So now, from the date of presentation of the plaint, for filing written statement, the time is prescribed. After the written statement, the documents have to be, or you have to file rather with the plaint and with the written statement, the documents. Then the issues are framed, admission denial is conducted, issues are framed. Then within 15 days, you have to file your list of witnesses, and thereafter the chief examination and everything. Now, the sole intent is that the time is curtailed in disposal of the suit. Now, all issues are to be settled by the time we reach Order 14 Rule 1 on the basis of the pleadings, documents, interrogatories, as Order 14 talks about. I don't want to go into detail, which all of you can look into. Now, when does a trial in a civil suit commence? As per Supreme Court, the trial of a civil suit commences on framing of issues and cases set down for recording of evidence. A slight dilution took place little later, where it said that when the chief examination affidavit under Order 18 Rule 4 is filed, at that point of time, the commencement of trial, the trial commences. Now, what has been seen is that once the issues are framed, we have to file a list of witnesses, and the examiner in chief by way of affidavit under Order 18 Rule 4. It is at that point of time the entire effort is put, search is conducted, who will give evidence, in support of which fact, which issue, what all documents are there on the record, who will prove the documents. So while preparing the affidavits of chief examination, a complete discussion takes place with clients, documents are scrutinized. The result is various mistakes happen. And to cover up those mistakes, various applications are filed. Now, what one has seen is there are two kinds of mistakes which take place. One, in the chief examination, you start pleading new facts. And second, various documents are introduced at the time of submission of chief examination. Now, as far as the facts which are newly added in the chief examination, even if objection is not taken by the other side, those new facts will not be taken into consideration because no evidence, it's a settled law that no evidence which has no foundation in the pleadings will be looked into. Now the documents aspect which objection is raised, you will have to file an application, seek permission of the court. Even if the permission is granted, it will take a considerable amount of time, and if the permission is not granted, those documents cannot be considered. Now, let me rephrase what the Supreme Court said. When does the trial commence? I would say the Supreme Court judgment in CPC, the trial commences when the issues are set and the matter is put for evidence. But for a lawyer, the trial commences when the suit is to be instituted, when the pleadings are to be drafted. Now, why I say this, in various judgments of Honorable Supreme Court and our Honorable Delhi High Court, the judgments have come where the judges have frowned upon the pleadings, the way they have been drafted, going to the extent of saying this is how it should not be drafted. Then, in another judgment, where the Honorable Court not only frowned upon the not so, what the word used is non-essential verbosity in the judgment, but it further went on to say that in order to expedite, all the stakeholders, that is litigants, counsels, should pay attention to making concise pleadings, avoiding unnecessary pleas, and filing relevant documents as evidence. The Honorable Court remarked on the habits of a counsel not paying attention to their client's claim or defense in the beginning, then filing a plethora of application to make up for the lacuna, and seeking extension of time to file reply despite knowing that it is not permitted. Now, there are several such cases and judgments which you all would have gone through, where the filing of the new documents or additional documents has been declined by the court. Now, coming back to the point when the plaint is being drafted, as I said, the trial for a counsel commences on that day. If you ask any old senior, or in the earlier times, because we who started almost three decades ago, we were on the cusp where several procedures, that Order 18 Rule 4 was not there. Chief examination had to be conducted in court. And mind you, all of the counsels who have practiced before 2002 and who have seen chief examination being recorded in court, it was the toughest. Because there were a lot of restrictions, no leading question to be asked. Leading questions are which is suggestive of answers. So the chief examination, while being recorded in the court, would only reduce to 1 or 2 pages, and then the cross examination will start. There was no need to prove already admitted documents because admission denial is conducted. So, when the pleadings are drafted, and if you draft the best of the pleading and take it to your senior for vetting or settlement, the first question which was asked was, how will you prove these facts? What is the evidence you have? Who will prove these facts? Who will give the evidence? What are the documents in support? Now, the purpose is that you draft one of the finest stories in the plaint, but ultimately those material facts have to be proved in the evidence, and they have to stand test of trial by cross examination of the other side. Now, without that, my most beautiful story will fail. So at that point of time, the first question needs to be asked by the counsels is, how will I prove those material facts pleaded in the plaint? What are the material documents? Now the requirements of Order 6 and Order 7, which all of you can go through, have to be complied with. The Order 6 and 7 basically provides what all is to be pleaded in the plaint, which is the material facts. No evidence is to be pleaded. Something which the law presumes is not to be pleaded. Effect of document, unless it is important, not to be pleaded. If it is a money suit, what money is to be claimed has to be pleaded. Now, with the recent amendment, what interest and how you are claiming has to be pleaded. Apart from that, who all should be parties? We have to take care under Order 1, because it's Order 6 and 7 are not just the two provisions. Order 1, Order 2, framing of the suit. It should include whole claim. Then we have joinder of causes of action, or 2 Rule 3. The example which is given is with regard to the immovable property. If it is a recovery of immovable property, you can only seek damages or mean profits. So on and so forth. Now, Order 6, Rule 6 to Rule 14 provides what all is to be included in plaint. Now, Rule 13, Order 6, Rule 13 provides that neither party need in any pleading allege any matter of fact which the law presumes in his favor, so as to which the burden of proof lies upon the other side, unless the same has been specifically denied, and provide examples for consideration of bill of exchange. Where the plaintiff sues on a bill of exchange, the consideration is presumed. Now, there are several such presumptions which arise as are provided in Indian Evidence Act. You can refer to Section 85 to 90A of the Indian Evidence Act, where several presumptions are talked about. What documents are presumed to be correct, what documents are there. So there are several presumptions which are there. There are several presumptions in various acts with regard to Section 230 of Contract Act, that there is a presumption of agency. So there are several presumptions which arise, which you have to plead as a fact, but the Order 6 Rule 13 specifies how you have to go about it. Now, if due care and caution is taken at the time of drafting of the plaint, that it meets the requirement of Order 6 Rule 7, Order 6 and Order 7, and also that who all would be giving the evidence on which aspect of the case, which material fact, who will be proving which document, I think a lot of time would be saved at that point. Now, filing of documents, when we file a plaint, we have taken care of this. Now, filing of documents. Now, with all the amendments, all documents which are in your power and possession, which are referred in the pleadings and which you intend to rely on have to be filed. Now, Order 7 Rule 14 provides for exemption of a document, that where a document is to be confronted to the plaintiff's witness during the cross-examination need not be. Similar is the provision in Order 8 Rule 1A4 and Order 11 Rule 1 and Rule 7C. But Order 13 Rule 1 also provides for filing of all original documents and also gives exemption to the original document required for during the cross-examination of the other party's witness is again to be confronted with. That is also exempted. Now, another aspect which I will like to point out, which is actually one is missing during the trial of the civil suits, is discovery, inspection, and interrogatories. Now, CPC in Order 11, Rule 1, 2, 12, and 15 clearly provides for discovery, inspection, and interrogatories. Now, if I just quote a part of the judgment where the Honorable Supreme Court said, a party to a suit should avail those provisions, and if any new ground becomes available on the basis of information secured by discovery, a party can amend in pleadings and introduce new facts and grounds which were not known earlier. The difficulty in securing relevant material or ignorance of existence of relevant material will not justify introduction of such material at the stage of evidence in the absence of pleadings on evidence led on an issue aspect not covered by the pleadings. The other side would be put to disadvantage. So the Order 11, the discovery of documents, inspection of documents, various interrogatories. Now, this provision is not being used in today's time. And believe me, if you use this provision where the documents are in sole custody of the other side, or there are certain issues which are the other side's pleadings are not clear, you ask for interrogatories. If this is utilized, then the issues under Order 14 reduce, because one of the point while drafting the framing of the issues is also look into the interrogatories apart from the documents. So the issues reduce. Now when we thereafter we go to after that list of documents, then there's an admission denial of documents is conducted. Then the question we reach is the framing of issues. Now the framing of issues, if the pleadings are concise, admission denial is conducted, interrogatories have been issued, you will realize that the issues which actually need trial, material facts, as you know, the issues are of nature, issues of fact or issues of law. Now, issues of law is one aspect, then issues of fact would reduce tremendously, thereby reducing the number of witnesses or the contents of the chief examination of different witnesses which you need to prove. Now, when we look at the list of witnesses, once the issues are framed, then Order 16 Rule 1 says that you have to file a list of witnesses within 15 days of issues having been framed. Now, our Delhi High Court rules and procedures, Delhi High Court rules of 2018, Chapter 11 provides for the form of list of witnesses. Now, Part A witness, who is to be examined on commission or video conferencing. Part B, who will produce only the documents. Now here again a small error is generally which I have seen is being which is being crept into the list of witnesses is we generally say so and so as a witness. Now, whether he is to give the oral document, oral evidence on the material facts, or he is to produce only the documents, or he has to produce both. He has to give oral evidence and also produce the document. Now, that has to be decided by you. If a person is only to produce documents, then he need not be cross-examined. That person comes in Part B, Evidence Act, as well as the Part B of our original side rules clarify that Part B business is not witnesses not to be cross-examined. Now, when we slightly go further, the framing of issues, as I said, if all these things are gone into, the issues will be concise. Now, all these steps which I have spoken about with regard to the pleadings, filing of document, discovery, inspection, interrogatories, all are self-regulating steps by the counsels and litigants. If the litigants have to give the correct picture, the counsel would be able to put them in a proper frame. If the documents ultimately have to be given by the litigant, but all these steps are self-regulating steps. And believe me, if all these things are taken into account and the pleadings are concise, the documents are proper, the interrogatories have been served, the issues are limited, your chief examination also gets reduced and limited, and so is your cross examination, and thereby your own docket, the entire brief gets reduced, and the judges are definitely going to appreciate that you have brought it down to a very limited issues which had need to be decided in that. Now, while drafting the chief examination under 18 Rule 4, what has been seen generally is in the cut copy paste era, the entire plaint or entire written statement is typed as a chief examination by way of an affidavit. So much so at several places, all of you would have seen where the cause of action and even jurisdiction paras or court fees paras are also included in the chief examination. I would say this needs to be again self-regulated, that one has to look into it so that these things are not included in the chief examination. When we say affidavit, now affidavit by its nature, a person who solemnly affirms that affidavit, who has to give as a chief examination, can only be in relation to the facts which is within his knowledge, or he has derived from the records or information. Now, that is the nature of affidavit. Now, that is under order 19 Rule 1 and 2, that what affidavit should contain and in what format. So, that itself is by nature that affidavit has to be restricted to the facts within the personal knowledge of the deponent, and the facts of which he has derived the knowledge from the record or the information, then those sources are to be disclosed. Affidavit has to be in that form. Affidavit need not be complete repetition as it is of the plaint. The plaint is already there. The plaint itself says no evidence to be stated. Then affidavit comes into picture. That affidavit has to stand the test of trial of order 19, how it has to be incorporated. Now that to be seen what is the purpose of affidavit, and if that is taken care of, your affidavit would reduce drastically the size, and you will appreciate that smaller the affidavit, the cross examination would automatically be not that long. Now, as regards the documents is concerned, which are to be exhibited or which are to be proved by chief examination. Now, Order 13, Rule 4 says that admissibility of the document will be decided in accordance with the provisions of law. The legal position, as we all know, is that merely marking of exhibit of a document does not prove it. It has to be proved by admissible evidence. Now, what one has seen is that during the chief examination, various admitted documents are also again tried to be proved, which is not required. A document which once has already been admitted, you need not prove it again in your chief examination. A mere para is sufficient. These documents are already admitted. This is how they are exhibited, because now the exhibition takes place during the when the affidavit is tendered. Now, as regards the proving of documents is concerned, Section 67 of the Evidence Act is clear that if a document is signed by a person, the signature of that person must be proved to be in his handwriting. And for proving such a handwriting, Section 45 to 47 and the act of opinion of experts and everybody has been looked into. Now, mere handwriting will not prove a document. The contents have to be proved. Now, Section 74, 76, 77, how the documents are there, how they need to be proved, which are forming acts of the records, which are public records, which are the documents, how they have to be proved is already provided. The presumption is there. When a civil suit at that point reaches at the stage of cross-examination, when chief examination is filed, your documents are exhibited, they are tendered, it has to stand the test of the cross-examination. The element which is again missing is the affidavits are filed, but the witness is never prepared. Now, the witness who's going to depose, who's going to stand the test of trial, the cross-examination by the other side, has to be prepared again. The witness must go through all the documents, must go through the pleadings of the parties. One important factor which is there is any affidavit which is to be filed for chief examination must be prepared in presence of the deponent, who should vouch it to be proper, who should confirm the contents of the same. Normally, what happens is you draft it, it is sent, the person signs it blindly, and is read for the first time when the cross examination is to take place and he is to next come to the court for cross examination. It only results that the person is ill prepared, he doesn't mean to what has been said in the affidavit, he can't support his own case or what has been stated there, and ultimately the cross examination and everything, the case suffers. So it is important that the deposition, the affidavit is prepared in the presence of the deponent. And then the deponent who's going to appear as a witness for cross examination must be prepared. All anticipated questions should be pointed out to him. All documents he should go through once the document is there. Most of the time, we've seen that the witness is looking at the document during the cross examination for the first time, or he's looking at the document saying, no, this is not complete. I meant to say this, or I meant to say that. So that aspect would be curtailed. This aspect, which actually harms the case, would also, uh, I would say, can be avoided. This is again a self regulation. This is not something which the courts are going, or there is no rule for that. Now, what is the stage we reach is the cross examination. Now, what is the purpose of cross examination? The purpose of cross examination is not merely to check the veracity. Of course, the veracity of what is stated has to be checked, but also as a we have to find out what information we need to extract from that witness and how that information is to be used in the case during your final arguments and how it will be against the said witness. Now, the Supreme Court has clearly said, and it's a settled law, that all witnesses speak are truthful unless you prove to the contrary. Remember, any person who's appearing as a witness, now I'm talking about the not from the plaintiff side, but as a any person who is to cross-examine the witness, is a person who's of some standing in society or otherwise. The person who's swearing an affidavit, because the affidavit we say solemnly affirm state as under, he comes to the court and is then given an oath, whatever I shall speak the truth. He's going to stand by what he has stated in his affidavit. He's not going to easily say, no, I have said it wrong and prove himself to be a liar. So he is going to withstand that. He's going to take it as far as possible. Now, while cross examining, what is the requirement? You have to not only go through at the point of the cross examination, entire brief once again with all documents. Check out all consistencies, inconsistencies in everything. With the affidavit, with the pleadings, affidavit with the documents, documents with the admission denial, with the issues, what all inconsistencies are there? What all omissions are there? Any material omission amounts to inconsistency. You have to impeach the witness. You have to discredit the witness. That is one aspect. You have to extract the information from the witness. Coming back, little back to the point that when the chief examination is tendered, the affidavit is tendered. Now, there is a very important aspect when the affidavit is being tendered. At that point of time, the objection with regard to mode of proof, competency, admissibility, all these have to be recorded. Now, there are two aspects. If a chief examination contains facts which are beyond pleadings, that has to be brought on record. Then the documents that are inadmissible in evidence, the documents which are inadmissible because of the mode of proof and competency. Now, documents which are inadmissible in evidence per se, which the law does recognize. For example, the lease, which is of more than 11 months, sale deeds, which are not registered, the law says will not be looked into in evidence. But as regards the documents, mode of proof and competency is concerned, for example, photocopy is filed. If you do not raise the objection, then that objection is no more available to you at a subsequent point of time. That goes. Now that has been clearly laid down by Supreme Court in several of the judgments that if an objection with regard while the document is being exhibited in evidence is not taken with regard to the mode of proof and competency, that cannot be raised at a subsequent stage. Now that objection has to be recorded when the document is tendered before you start the cross-examination. The chief examination when we say it, I'll just come a little later to the cross examination aspect. The framing of issues places certain onus. Now, there is a burden of proof. The burden of proof remains constant all through the proceedings. Whoever alleges must prove it. But the onus which is placed in the issues keeps on shifting during the entire. Now you have seen that Order 18, Rule 4, the affidavit has to be filed. In Order 18, Rule 3 is there that if the person has to, plaintiff has to examine himself as a witness, he should appear first. We reach at the stage of cross-examination. The cross-examination has to commence and it needs preparation. I'll quote from Abraham Lincoln's famous quote that if I 8 hours to cut a tree, I'll use 6 hours to sharpen my axe. So it is all a preparation, preparation, and preparation. For purposes of cross-examination, you would had several lectures on this issue that you should be composed, you should not lose your cool, you should know what you want to extract, you should also know what questions you have to ask. But two aspects which I will point out is that before the cross-examination, you need to know two aspects very clear, which is the law which governs the suit or the proceedings, and the rules of evidence. The rules of evidence in CPC and Evidence Act, what all to be done, and the field of law in which your case is covered, whatever the field it may be. Because that is where cross-examination, what you need to extract, what has been done, whether the witness has been able to discharge the onus, whether the material fact has been proved, whether the document has been proved, whether the document which is produced is admissible. Now, all those things, whether the presumption, whether the burden of proof, now all these things can only be taken a note of if you are well versed in your field of law and the rules of evidence. Now, as far as rules of cross-examination are concerned, you all have done the cross-examination at several stages. You have also gone through, but just few of the can quickly, I can see the time, I can quickly just point out. Now, evidence has to be evaluated in the light of the pleadings. So, as I said, inconsistencies, omissions, the purposes, they all should be seen. Before you venture for a examination, please ask yourself one question. What all I need to extract from this witness? Mark it. Prepare your questions accordingly. The question should be very short, not very long, winding questions. Shorter question, shorter answer. The intent is that while cross-examining the witness should agree with the case set up by you. Never give him a chance to repeat its testimony. If you get any favorable answer or admission, then stop. Change the track. Don't ask for clarification at that point of time. Don't ask him a chance to explain what he meant, what he wanted to say. Now, once the contradictions are verified, once the omissions are checked, inconsistencies are there, how the document to be proved, Then you have to see whether I need to cross examine in the witness. It is that every witness needs to be cross examined. If a witness has not proved anything, or witness has not said anything to incriminate you, there is no point in cross examining. If you are in doubt, don't ask that question. And one principle, or golden rule, which everyone would say, and even I would is never ask a question which you do not know the answer. Anticipate, anticipate, and anticipate. These are the three words for the cross examination. That whenever you ask a question, anticipate the answer. Because your anticipation of the answer, it may come within that corner. Whatever you have thought of would decide your next question. So, in preparation of the brief and anticipation of the answer is very, very important. See, ultimately, in a suit, a defense is there, the plaint is there, the written statement has come, everything has come when you are cross examining. Now, the full story, the story which will make one aspect, if we join it together, of plaintiff and defense, should be one story. The pieces of jigsaw puzzle, in the end of the day, the judge has to pass a judgment. It is on who's right and who's wrong, who's entitled and who's not entitled, what relief to be granted and what not to be granted. Now, ultimately, the judge, while going through the two stories set up, has to balance it out, because ultimately the two stories under one transaction, one story given by two people in their own ways. So the logical thinking of counsel will allow him to put those jigsaw puzzle pieces at the right places, and that is where the art of cross examination lies. It only comes with experience and time. There is no formula, there is no method, but definitely one method which is consistent is, which is absolute preparation. You're putting yourself as a witness and thinking that how you will answer. These facts are there, how you will anticipate, what kind of answers would come, what kind of questions need to be asked. Try to be polite. There is no need to be aggressive. Many witnesses have this tendency to treat the counsel of the side as a bigger opponent than even the other party. Because ultimately for him, the case is won or lost because how you are examining, how you are going ahead. So they treat you like that. But do not get flustered. You are not to enter into any kind of an issue with the witness. Your purpose should be focused at what you have to extract and how you have to go about it. Now, examination, you should restrict to issue base. Your each question, as I said, should be a short one and related to the fact on which you want to. It should not be roving inquiry. The moment you give a chance in roving inquiry, please take it that the person is going to give an answer which will not be helpful to your client's case. So come back. I'm looking at the time. If I come back to the points, the trial of a civil suit does not necessarily commence with the cross examination. It commences from the drafting. Your pleading should be concise within the four corners of Order 6 and Order 7. All those presumptions which are there, what material facts to be stated, who will prove those material facts, what documents, they all be sealed in the beginning. They should not be left at last. They should be prepared in the beginning. Mind you, if you will prepare it in the beginning while drafting the plaint, you will save a lot of time. Lot of time in that brief, because ultimately while drafting you have put in so much of time, and now put little bit extra time to cut down on the verbosity, down on the whatever is not needed. Because I have seen a plaint once. I was appearing for a defendant, and when I received the plaint and I appeared in High Court, the during those days, 90 and 120 days was not there. So I smilingly asked, some lords, I need 4 months time to file written statement. Immediately the answer came, why, Mr. Airi, why do you need 4 months? I said, lords, the plaint itself is running in 120 pages. For 120 pages, I don't know how much time I would have spent to prepare a plaint. At least I need 4 months. Even the judge was surprised to look at it. He says, what do you mean by 120 pages plaint? And it was a specific performance suit. And the part one file, which I caught, when the judge picked up and he looked at it, he just smiled. And the order in writing was passed by him that Mr. Airi has pointed out that the plaint is running into 120 pages and he needs 4 months time to file WS. I allow 3 months. Now that kind of in a specific performance suit or any of the recovery suit, none of them is required. They can be curtailed if we go within that system and procedures. I think entire trial and the time period would be lesser. Now in video conferencing, in the time of COVID and even otherwise, I would request all of you to go to original side rules of Delhi Court. And there's an extra B. As I said in part A, witness where video conferencing is required, who's to be examined by video conferencing and commission. And the rules which have been framed by Delhi High Court for the purposes of evidence recorded by video conferences, which is annexure B to the original side rules. It gives a detail what systems, where the coordinators have to sit, which period has to take place, how the courtesies have to be done. The rules and procedures are identical, which are to be followed in video conferencing, which are to be followed during the oral evidence being recorded in open court. The only difference is that a parallel set of the court file has to be there at the point where the witness is sitting, because ultimately we have to confront the witness with a lot of things, with the paras, with the plaint, with the evidence, with the documents. So a parallel set has to be present to go there. The person who's sitting in the witness point or the remote point, with what is called during the in the rules, it has to be either in the embassy if it is side, or a notary public which has been assigned by the how what steps have to be taken. You have to make it sure that some of your representative was there. The person who's sitting in the camera, there is no other person in the person who's sitting and who's the coordinator at the remote point has to make sure that there is no one else in the courtroom in the room where the witness is sitting. So on and so forth. Those rules are also provided in the uh, in our original side rules in different time. Now, I hope I've already, I think, exceeded the time. And if there are any questions, the judgment which is which says is that the documents we prove is to be vouchsafed by the person who has given is the Narmada Gupta, and the on interrogatories is State Bank of India versus S.N. Goel, which is 2008, Volume 8, SCC, page 92, and the admissibility of documents with regard to the objections is RVE Chala Gounder versus Arul, which is 2003, Volume 8, SCC 52. Now, these judgments are which are referred in three of the proceedings with regard to the documents which are there. Coming back to one important aspect which have been asked is when we witness is cross in rebuttal, which has oftenly asked a question to me. When you look at the CPC, the issues are named and the onus is placed on both the parties. Order 18 Rule 3 specifies that you can lead evidence on issue placed on you, and you can reserve your right to give evidence on the issues the onus is on the other party. That is, when you can choose to lead evidence only on the limited issues which the onus is on you, with reserving your right. So that is affirmative. So then you can give your evidence in rebuttal. But if you choose to give entire evidence, all issues, even if the onus is on the other side, in your affidavit, and you close the evidence, then there is no right of rebuttal. There is no right of rebuttal with regard to the evidence on which the onus is already on you. Because only in a case where the onus is on the side, you can ask for a rebuttal. That is the Order 18 rule. Now, various applications are filed where the uh, parties or the plaintiff is asking for a rebuttal evidence on the issue where the onus is on the plaintiff himself. That is not permissible. That will be against the teeth of the Order 18 Rule 3. So you have not reserved your right, and especially in an issue which is on you, you have to give the entire evidence. So there is no question of any of these rebuttal being carried out at that point of time. If I just simply before I conclude, point out certain sections to you with regard to the Indian Evidence Act. Order of, when we say, see section 118 to 134 of the Evidence Act, which contains around 17 sections with regard to competency, compellability of the evidence, privileges, quality of witnesses required for judicial decisions. Now, Chapter 10 is, for example, one section 135, order of production of witnesses regulated as per law or practice for the time being, and in the absence of such law, on the discretion of court. Now, section 136 is to decide the admissibility of document of evidence, how fact proved would be relevant. Now, as I was submitting and pointing out to you that part B of the witness says the witness is only a document producing witness, read it with section 139 of Evidence Act. which says the person whose witness who's producing document need not be cross-examined. If a person's deposition is contained in a document, the document is to be produced, you need not cross-examine. That is 144, section 140. The veracity and how you can challenge the credibility of a witness, that is permitted in the Evidence Act 146 to 150 and 155. When it comes to public records, there is a presumption 74, 75 and 77 that whatever the public documents are there, public records are there, if they are certified, they are presumed to have been during the course of the person's regular course of their duties. There is a presumption to the attorney under section 85. Then presumption with regard to electronic records. Now, when we look at section 65, section 66 of Evidence Act, now 65B has come into picture. The certificate which is required if the electronic records are being produced, you have to file that. Now, section 65B complies is mandatory. Similarly, 85B is there with regard to the presumption of electronic record and electronic signatures being secure and not altered unless contrary is proved. 88A deals with the original messages. Now, section 90 dealt with any document which is more than 30-year-old presumed to be correct. Now, 90A has been added with regard to the electronic records which are more than 5-year-old. Now, all these aspects where the presumption arises, may presume, shall presume, how the presumption has to be dealt with. Now, all presumptions are rebuttable. The presumption, I must also clarify a small nuance for you, that a presumption is only available at the initial point. Every presumption is rebuttable. If the presumption is rebutted, then that presumption is not available to the other side, even if he has proved its case, because then the question of onus, then he can't rely on presumptions. It's no more again available. So the presumptions are rebuttable. Then we have section 91, 92. Document is the sole evidence. So you need not plead the contents of the document. The 91 and 92 is very clear that anything which is recorded in a document required in law or otherwise, then that is the sole repository of the transaction between parties. Now all provisions, as I said, that the trial of a suit is also to understand the field of law which applies to the suit and the rules of evidence. I hope all have been able to hear me properly, and I wish everyone that every one of you is safe, and I all look forward to see you all in courts as early as possible when this opens up. Taken more than an hour. I hope the lawyer's wit is angry with me on this aspect. Uh, if there is any question or any issue, all of you know me well. You can send it further or send a question anytime, and I'll be able to answer those and give you a further clarification. Thank you, and thanks, lawyers wit again. I think, yeah, uh, with regard to CA certificate, see, CA certificate to see whether the person is appearing as a witness, whether he is an internal auditor or an external auditor. Section 66 of the Evidence Act, section provides for the second 65. Hello. Yeah, can you hear me? If he is an evidence, CA is giving an evidence on the basis of deviation from the records. If the record is voluminous, there is a judgment on record that if there is a voluminous and on the basis of that records he has prepared an act, then that certificate can be into. But while cross-examining that, CA can ask him what is the basis. All those records can be coming on record, and that is a secondary evidence that the person is giving. It's not the primary evidence. The CA certificate is based on documents on which he has prepared it. So definitely he can be cross-examined. Now you can, if that CA certificate who's produced for recovery of the amounts and everything, it can be rebutted. The person has to give the details, what all has been verifying, whether he's an internal auditor, whether he's an external auditor, what documents he gone through, what is the basis he has produced. If I just point out, section 65 G provides when the original is in numerous accounts and other documents. Now, in such a case, secondary evidence relating to documents can be given, but that there is no presumption to it. You still can ask those documents and ask for discovery and production of those documents on the basis of which those certificates have been given. My apologies, I think I failed to. Another question which has been asked in regard to the confrontation of the document. As I said, under Order 13, Rule 1.4, any document in original can be confronted to the other side. But mind, under the commercial dispute, all documents have produced on record, but still 13.1 is as it is. So if that is a document which you are relying on, because giving an affidavit on record that you have filed all documents of power and possession, surprise element in commercial dispute, there is a gray area. But as far as the civil suit is concerned, the disputes are concerned, you can confront witness with that document, but again, make sure that the document is of a witness signed by him. If you are confronting him a document of some other person who's signatory or author, there will be a difficulty. I think I'll conclude this. I have already taken a lot of time. I thank all of you and thanks Lawyer Wade for giving me this opportunity to interact with you. I hope I've been able to make slight difference, and if there has been any repetition, I think you will, as a friend, will excuse for that. And wish you all the best. Stay safe, stay healthy. and look forward to see you all, and let's pray that the situation returns to the normal at the earliest. We are able to get to our favorite place in canteen with our samosas and another round of discussion. Thank you all of you. Thank you.